of Crown Prosecutor from 2014 to 2019. Prior to becoming the DPP, Mr. Smith served as a director of law reform and special legal projects in the Ministry of Legal Affairs in Antigua and Barbuda from 2019 to 2023. He was recently appointed to act as a special prosecutor under the Anti-Corruption Act of 2023, tasked with investigating and prosecuting offenses under the Act and under the Integrity Public Life Act. Mr. Smith has a strong interest in reforming the criminal justice system. He envisions a society where the rule of law prevails, where the rights of all individuals are protected regardless of race, sex, beliefs, political affiliation, or social standing, and where the public can trust the administration of justice. To this end, he has been working closely with the Attorney General to advance reforms aimed at reducing delays, protecting vulnerable witnesses, improving diversion programs, strengthening plea negotiations, and enhancing overall efficiency in the system. With that said, I will now open the floor to Ms. Sherry and Liburd Charles to start our discussion.
A pleasant good morning to everyone under the sound of my voice. It is my pleasure to be here along with our esteemed Director of Public Prosecutions. And as the Bar Association is celebrating a week of activities, we are pleased to be able to have this radio discussion where we can educate members of the public, which is part of our mandate as lawyers. I'm going to just give a brief introduction to the topic, which is landlord duties and tenants' rights, after which we will open the floor to allow for questions that may arise based on our discussion. I'm going to try to speak in a manner that would be as simple as possible, because at the end of the day, we want the listening public to understand what it is we are communicating, minus the legalese. So whenever we hear about the topic of landlord and tenant, it is not something that is new to anyone. But one of the most important things that I think is sometimes overlooked by the public is that a landlord and tenant relationship, first of all, is a relationship. And just like any other relationship that you may have, the landlord and tenant relationship has expectations, it has obligations, and it has boundaries that must be respected in order for that relationship to work. In terms of the creation of the landlord and tenant relationship, that is usually done by what we call a lease. And when we speak of a tenancy, we are speaking of that contract or that legal arrangement which gives the tenant the right to occupy property that belongs to another person. There are certain key features of a landlord and tenant relationship, and one of them is what we know in the law as exclusive possession. And all that means is that a tenant must be given the right to exclude anyone else from the property, even the landlord himself. That is what exclusive possession means. Now, the landlord and tenant relationship, apart from being a contract, also creates an interest in land. And when we speak in the law of creating an interest in land, we are speaking about the creation of a right to possess a property rather than just a personal right to be there. And that is important because that legal right, that interest in land, is protected by the law. And so a tenant, by paying their rent, would be able to occupy the premises without the fear of being evicted. As I'm speaking about what constitute a landlord and tenant relationship, it is important to at least highlight what is not a landlord and tenant relationship. So for example, you may have like your adult children living in your home and they may be contributing to household expenses. That is not a tenancy. You may have situations where, you may invite, your boyfriend or your girlfriend to live with you. And, as a part of the living arrangement, they contribute to monthly household expenses. That is not a tenancy situation. And it is important for us to understand what is not, because in terms of the rights and obligations that flow from a tenancy, it would not arise in those kind of familial arrangements or, licenses, as we call them. Now, I will just briefly look at some of the landlord duties, and then I will go into tenants' rights. Now, whenever I'm advising anyone when it comes to matters involving property or even matters relating to landlord and tenant, one of the things that I always say is a saying that we have in St. Kitts and Nevis, is that in approaching this relationship, an ounce of prevention is better than a pound of cure. Because a lot of the times, by the time the landlord or the tenant reaches into a lawyer's office, it is after the lease would have been signed, problems would have already arisen, and that is when, after the fact, persons are seeking legal advice. What I'm suggesting is that you get the legal advice upfront, and that may assist in terms of preventing some of the problems and situations that can occur during the course of a lease. And so in terms of a landlord, one of the things I've recognized is that there are duties, and I'm putting duties in bracket, that a landlord ought to ensure that they cover even before you get to the situation where you are entering a lease agreement. And I'm going to look at three things. 1, know your potential tenant. 2, vet your potential tenant. And 3, enter a written lease. I have noticed over the years, especially when it comes to residential tenancies, that a lot of landlords across the Federation are renting spaces to persons whose identity they have not verified. And it is a major problem in our Federation, partly because many persons in the Federation are known by aliases. Sometimes an alias is easy to identify. So for example, somebody might introduce themselves to you as Black Man or Coolie or something like that. And so you are able to tell from, the name that must be an alias, because no parent would just name their child Black Man or Coolie. But there are other circumstances where persons are known by names that are not on their birth certificates. And landlords sometimes fall into the trap of entering lease agreements without any kind of verification of identity. And it may sound like a simple point, but it's very important, especially if problems develop later. You can have somebody, for example, popularly known as, Melissa Cunningham, for example. And when you ask Melissa Cunningham for her, identification card, you recognize that Melissa isn't her name, and her name is actually Roxanne, but every single person knows her as Melissa. And so it is important that the landlords take the time to at least get a photo ID for any prospective tenant. Because if you enter into a lease with someone with an alias, and by the time problems arise, they are no longer in your premises, you're going to have a problem when you take your matter to a lawyer for advice in terms of finding this individual. And it can, of course, lead to delays in any legal process that you may be contemplating. And so another way in which I've seen this problem arise is also in terms of when you're dealing with non-nationals. Because sometimes it's possible to say, well, this is St. Kitts, I know everybody. But I have seen situations where students enter into lease agreements using names that are not on any identification that they have. And those things are only discovered after the fact. So the solution to that problem, if you're considering entering a lease agreement, is for you to request and insist on at least one photo identification for your prospective tenant. It could be a passport, it could be a social security card, driver's license, whatever it is. And if a prospective tenant refuses to give you a copy of an identification, well, that clearly can be looked at as a red flag. And if you already have a lease that you're operating under, and you have no ID for your tenant, you can still request it even after the fact. And the rationale behind of this is to solve problems that may occur down the road. Another issue is the vetting of the potential tenant. It is not something that is in our culture, but based on what I've seen over the past years, it is something that a landlord ought to do as a matter of course in order to protect himself from tenants that may not be in a financial position to meet the obligations under the lease. In other more developed countries, there are background checks, there are credit scores, there are a lot of different indices that are used before you can even qualify to rent a space. Because remember, we're not just talking about permission to remain, we're talking about an interest in land. And when landlords take the approach where they are not vetting the persons who are entering their spaces, it will only lead to problems down the road. And when I speak of vetting, I'm speaking of asking the relevant questions in response to an inquiry by a prospective tenant in order to give you a clearer indication of who it is you are allowing on your premises, especially in cases where the landlord may be living on the same premises and the space may just be like an apartment above or below, or somewhere in the same property. Things that you will ask about and would be things like the age of your prospective tenant, the place of employment of your prospective tenant is also very important. And the employment comes in because as a landlord, you want to ensure that whoever it is you're renting to actually has the ability to pay the rent. And so, for example, if you have a property that you've advertised for rent and your monthly ask in terms of your rental income is $1,500 per month, and your prospective tenant works for a minimum wage, and there is no additional income, you will have to ask yourself the question, how will this tenant with that income be able to maintain the rent on a monthly basis? It doesn't make sense to wait at the end until the lease has been signed, the person has entered possession, And at that stage, you're saying, they can't pay it. So the ability of the tenant to pay should be a major decider in whether or not you rent the premises to them. Even in a case where, as in St. Kitts and Nevis, we have many persons who are self-employed. They may not have a definite place of employment, but if they are self-employed, that is something that would be relevant information for you to know. Because I'm thinking of a situation where you may be renting your premises for residential purposes only, and you don't do your due diligence, and let's say your tenant is a professional cook and they sell food for a living and they have no established place of business. Well, in a situation like that, it is quite possible that the residential accommodation will also be used for the commercial purpose of cooking and selling food. And those are things that could be covered for in a lease agreement just from you asking certain questions from the get-go. I'm thinking of situations, for example, you may be renting to a mechanic, and that mechanic may not have a shop. Well, chances are, if the person is actively engaged as a mechanic, they don't have a place of business, it is very likely that your residential accommodation may become that mechanic's shop. And so you may have a situation where, there are many vehicles that are parked outside of the premises or in the premises because you did not take the time to vet. Another issue that arises a lot in terms of tenants is issues of pets. A lot of tenants, they are pet owners, and the pets are basically living on the inside of the premises. And large dogs I'm thinking about, because I'm thinking of a case years ago where a tenant had a large dog living inside of the premises with them. And the damage that was done to that furnished accommodation from the presence of that dog, I think it was a Great Dane, a very big dog, it really set the landlord back financially. And so those are the kind of vetting that would have to be done. The most important thing I think a landlord ought to do is to find out if it is the tenant is moving from a previous rented accommodation. They should ask for the name and number for the previous landlord, or at least a reference from a previous landlord. And the reason for this is that you want to know if this person whom you are renting your premises to have a reputation of not paying their rent. Do they have a reputation of damaging property? What was the condition in which they left their former landlord's property in? Now, you may get a negative report and still decide to rent, but at least you are not engaging in it in a blind fashion. You have persons who I am aware that the only thing a landlord gets from them is a deposit and first month's rent. And then after they pay that deposit and first month's rent, they pay nothing else. And by the time the landlord takes a part with them, a few months pass. Gives them a notice to quit, that's another month or two. Takes it to court, that's another month or two. And you have situations where 8, 9, 10 months, no rent. When they finally leave, all they do is go into another rented premises and repeat the cycle. And so sometimes you have tenants who are looking a free ride, and if you are not diligent, if you're just anxious to get your place rented, you're gonna have a situation where somebody will come, pay that first month's rent and the deposit, and you get nothing else. So these are the things that you do in front in order to save you headache and stress down the road. Yes.
Um, all the questions that you would be directing to our speaker, Miss Sherry and Liburd Charles, you could please put it in the chat from now, so when it comes forward, we would be on par with that. You could put it in the Win Media SKN Live YouTube link, or you can call 466-0989, 662-0989, or 762-0989. You could proceed.
Yes, so we were just dealing with ways in which a prospective landlord can vet, a prospective tenants. This is even before a lease is signed or before any agreement is formalized. I'm suggesting that the due diligence is done upfront because it's going to save a lot of stress and time at the back end. And the final thing I wanted to touch on when it comes to the vetting of a prospective tenant, if you're a landlord or you're considering renting, is that tenant's family situation. If it is, for example, what you're renting is a studio apartment, and you intend that a maximum of 2 persons are going to be living in your studio apartment, but your tenant has 3 minor children, maybe a boyfriend or a girlfriend, the chances are when you lease that property to that individual, the entire family is moving into the property. And that would have an impact in terms of wear and tear on the property. So that is a very important consideration when you're renting. I understand that we have a caller.
Yes.
Moderator, you could proceed with your question.
Yes. Thank you. My name is Winston Welcome, and I'm calling from the New York area.
Could you speak?
Yes. I said my name is Winston Welcome, and I'm very versed when it comes around housing, landlord and tenant situation. Now, from my perspective, I took a real estate class, but I never went to do the examining to be a broker or a salesman. I did fit at that for a reason. But saying that to say, between a landlord and a tenant, each one has their rights. And let me deal with the tenant side. Even though a vetting took place, right, to find out about that person, somewhere along the way, sometime, either the tenant breach the agreement or the landlord. Landlord do that in terms of discrimination. I don't know what is considered as legal discrimination in the Federation of St. Kitts and Nevis. But some landlords sometimes become very abusive in terms of an apartment, a basement, or whatever they are renting might need certain livable standards. But sometimes you take a chance, desperation with the tenant itself. And here it comes. If a landlord does not make a commitment for a standard of living, quality of life, and the tenant might be weary of the landlord not doing that due diligence, all they need is the money to continue from the tenant to advance progressive work or to get work done. So you're going to see where confusion develops. Tenant might tend to say, okay, I will accommodate what they think is needed, and they deduct it from the rent, and the landlord might be angry if they allow that, if there is some kind of control. But one should put on the book certain mandatory vetting protocols to eliminate some problems. But there will always be problems. So what we'll consider and what are the actions if discrimination on the discrimination against the tenant And also tenants could be very abusive too. Okay? And sometimes there are empathy between from the landlord side if there are shortage of the anticipation. But what we'll consider as discrimination, tell the world, between a landlord and a tenant, vice versa. I will leave it there. I have a lot more questions to ask, and I am glad to see the panel. And my lady, I like the way you pose your posture. You are well to me back and look very confident. So in my book, I will not rate you yet, but carry on. I'll take it back to you.
Yes, thank you very much for your contribution. It seems as though the caller used the words discrimination and abuse almost interchangeably. Now, notwithstanding persons are in a landlord and tenant relationship, that does not mean that the other laws of the Federation do not apply. And so in a case of abuse, if you're describing physical or verbal abuse, there is recourse to that. And in terms of, and that is on either end, whether it's the landlord or the tenant. No one should be verbally or abusing anyone else simply because they are in a landlord and tenant relationship. So the laws apply to that situation. And then in terms of discrimination, I'm not sure exactly what you mean by discrimination in terms of what, in the context in which you were speaking, but vetting of a prospective tenant is not discriminating. What you're trying to do is to decide whether or not the relationship will work. And most landlords enter into tenancies for financial reasons. So if it is that you enter into a lease based on sympathy or desperation on the part of the tenant, well, that would be a matter for the landlord. But at the end of the day, the landlord enters the tenancy with a view to profit and to make money from the use of the space. And these points that I'm raising will not eliminate problems, but it would cause you to avoid avoidable problems. So at the end of the day, it's a risk assessment that I'm suggesting is done upfront, not to eliminate every single issue that would come up, but definitely some avoidable issues can be avoided by that kind of vetting process. Yes, we have another caller. Go ahead.
Good morning, caller.
Hello.
Good morning.
Good. Is this me? For me? Good morning.
Yes, this is for you.
Oh, okay. Good morning to you all.
Good morning again. You could go ahead and say your question.
Yes.
Question.
Yeah, I would like to know a few things. Question one, the lady talk about, the tenants and the landlord sort of agreement. And there are some tenants, when they okay to rent the house, they pay the down deposit and the first month's rent and nothing else after that. And then she talked about the process if this ends in court. Sometimes it might reach up to 10 months. I assume by the time that reaches to the court, the tenant is still living in the landlord's house under the tenancy agreement. I assume so. Now, what I would like to know is, when this happens, does the court make the tenant pay up all that is owed to the landlord? Now, whether a vetting process was done or not, the fact is the tenant was inside there, they used the house, it was to be paid for. I just want to know if the court makes them pay in the end, or they just dismiss whatever and then they allow that person to move on and to do that to someone else. And on the backdrop of that, I would like to know if there is anything that is recorded in the courts on the dealings or the doings of this tenant. When they do these things, do they have any record there that people can reference in the future or against them, or in the case that they might have to be taken back to court? So the court already knows, well, hey, look, okay, this is like a pattern, but something has to be done here to stop this. That's one. Two, in the case that a tenant rents a place and over time, you know, things need to be maintained and so on. So let's say the roof starts leaking, let's say a window starts falling out, and it is very uncomfortable for the person, for the tenant in that house. They go and they inform the landlord about this. And when you look, the landlord is not doing anything at all. So for months, they expect the tenant to pay, and the tenant is paying, but nothing is done to the house. Now, I would like to know if there is anything in the law, if it goes that far, where the tenant could withhold the money or the rent money until the landlord fixes whatever damage to the house. Or if the money is paid still, and let's say it gets to the court and so on, is there any way in the law to make the landlord repay or pay the tenant some kind of money for their discomfort and distress? And finally, yes, you talk about what the tenant and landlord agreement is and what that thing is really about. But in some instances, a person might take in somebody because that person is really in distress. Take them in their house. You know, it is not really a tenant and landlord basis anything. Just because a person is going through some times of hardship and they take them in. Okay, they will tell them, all right, they're taking you in. This is what I expect of you under my roof. Okay, well, I expect you to just, you know, contribute something. And this is how long I expect you to stay. Because by this time, you should be out looking for somewhere to go. Okay? I'm just only sheltering you for the time being to help situation while you get yourself calmed down, as the case may be. And then afterwards, you might realize that the person doesn't want to leave. And they cause problems, all kinds of things there for the owner of the house, right? Now, the owner now might go and put that person out of the house. When you look, the police comes, and the police is going to decide that the owner is wrong to put that person out. My thing is, I never involved the police when I allowed that person in out of the kindness of my heart. And now the situation arises where living together becomes untenable, even in the short periods of space. What right now the police has to tell me, the owner, that I don't have that right, that prerogative to put that person out of my house? How is it now that the police wants to bring in the court in it, which to me is only a means of extracting money from that landowner, or the house owner, the home owner? So I don't see in which way the police and the court has to be involved, because they're going to come and tell me I have to find, I will not say me, not me, I'm talking in general. I have to find a lawyer to settle that matter. No agreement was written. We didn't sign any agreement. I only just did it. So if I took you in and it comes to the point where it's untenable, even before the time approaches for you to go, I put you out. What right they have to tell me that I have no right to put that person out? And so, like you said, the process, this takes 2 months, 3 months, 4 months, and they're living under my house before. No. So could you kindly answer those questions for me, please?
Well, we thank the caller for that. That was a mouthful. I don't know if I'm going to remember everything, but I guess I'll start with the last scenario. Just to state that nothing that I am saying here should be construed as legal advice on any particular situation. A lot of what we are saying will depend on, one, whether or not there is a lease agreement, what are the rights and obligations of the parties. So I'm only going to be able to address your issues in a very general way because we're not giving legal advice via this medium. Now, in a situation where you have someone in your premises other than a landlord and tenant relationship, the law describes those persons as licensees. And if somebody has a license to be on your premises, it means that if you want them off, you have to revoke that license in a particular way or manner. What you raised as a strength, the fact that you don't have an agreement, the fact that it's not their house, may not necessarily be a strength, because if you had an agreement, if you had a lease or something like that, then you would have been able to enforce it. And a lot of the times in these domestic situations, there are a lot of other issues at play. Somebody may come onto your premises for a particular reason. They may remain there for a length of time. And when you're saying that it's not their property, they may be saying in response, well, I contributed to this. I put on this bedroom. I did whatever. So a lot of those domestic cases are not easily resolved by someone simply saying, well, see, I have the title, because the law recognizes other interests in land other than legal interests. So it's possible that in a domestic situation, someone can acquire an equitable interest in a property based on contributions. And that is why you probably would get the advice, if the police is called, that it will have to be worked out in court. Because third parties cannot, outside of a court situation, determine definitively these rights. In a lot of cases, party A is saying X and party B is saying the complete opposite of it. And a police would only get involved in a situation like what you're describing if there is some crime, breach of the peace, or some kind of, criminal matter that would draw the police to a particular place. Those matters outside of that are civil matters that you'd have to get advice from a lawyer in terms of how you could move forward. Let me see what the other, in terms of the point that you raised initially about if matters are taken to court. Now, if you have a tenant who is not paying rent, as a landlord, you have an obligation, because an interest in land has been created. You have to serve on that tenant a notice to quit. It's not something you just open your mouth and say, well, leave my property, you ain't paying rent. And so that is why, I'm stressing on the vetting and all of those things, because once you enter that landlord and tenant relationship, it doesn't come to an end simply because you get fed up of your tenant. You have to serve them by law with a notice to quit and give them this specific amount of time that is required, either under the statute, if it is you don't have a written lease, or whatever timelines your lease says that they have. Once that timeline would have expired and the tenant still hasn't moved, they're still saying they're not paying any rent, or sometimes they just, cry financial difficulties, then you have a right to bring an action in the magistrate court or in the high court, depending on the value of the arrears of rent. That takes time because you're talking about service of processes. And then by the time you get before the magistrate or the judge, rents would have likely to have accrued during that period. If the tenant is still in possession, the law refers to what is payable at the end of a notice to quit. Between that time and when you get possession, the law calls it means profit, which is basically in the same sum as the rent. and that would be paid until the tenant actually leaves or gives up possession of the property. So yes, a landlord would recover, but you must appreciate that if you're recovering from someone who doesn't have a lot of money, or someone whose finances are not in a good place, maybe they owe a lot of other persons, your likelihood of actually taking hold of that judgment sum, even though you have a judgment sum, is very slim. Because at the end of the day, the court will not order a sum to be paid outside of a means test. So you really want to try to avoid renting to persons who simply cannot pay rent. Of course, you're going to have situations where things happen, change of circumstance. But as it relates to that, yes, you'll get back whatever monies via judgment. And whether or not you actually get back your monies now is a matter of whether or not the tenant is able to afford. I think there were two other questions, and I am not. Yes, okay, so in terms of that, you're delving into an area which is normally covered by the lease. In the sense that the obligations to repair, meaning who is responsible for what, is usually set out in the lease agreement. But as a guide, when it comes to structural things like the roof, the windows, those major structural things, those are usually the responsibility of the landlord. And the tenant now has an obligation not to destroy the premises, not to commit waste. And if you have a situation where the premises are, let's say you have a leaky roof, or, there is some damage that is causing the tenant discomfort, the tenant does have a recourse for that, but the recourse is not withholding rent. Rent would still have to be paid, but the tenant, if the tenant suffers inconvenience, losses, let's say the roof is leaking, your furniture gets, damaged or anything like that, you do have a recourse under your lease. And in a situation like that, you take advice from one of the many competent lawyers in the Federation, and they will give you the specifics as to how you go about addressing those issues in the context of a lease agreement.
Listeners, we'll be taking a short commercial break. We'll be back in about 5 minutes.
Found the sound 98.9 FM.
If you need protection, you need one who you can trust to secure your investment. You need one who'll do you just. TDC Insurance, you're the one that you can trust. TDC Insurance, you're always safe with us. TDC Insurance is your go-to insurance company for all your insurance needs. We take pride in offering you the best solutions and ensuring our customers are fully satisfied. TDC Insurance, we take good care of you, guaranteeing you peace of mind. You're always safe with us.
When you need better service, Rams is always
Welcome back, listeners, to the 2025 Law Week radio discussion. We'll continue with Miss Sherry and Liburd Charles.
Good morning.
Good morning, caller.
Yes, I am glad you are discussing that matter. Sorry, I didn't tune in before. Now, I have a situation. Well, a friend of mine, a college friend of mine, owned a house. She did most of the renovation on it. Anyway, she instructed the then present tenant to pay. She lives in the Virgin Islands, to pay me the rent, to which they agreed, right? So every month the person would pay. Some circumstances came up where the daughter went away to study. And so she said, Mrs. Henry, I can't pay the full amount every month, but I will try. Being a good Christian, like I said, all right, just try and pay. The daughter came back home from college, and its mother told her, well, the rent was, I think it was $400 a month, something like that. And a 3-bedroom house, eh? Oh, she said, well, she's not going to give nothing. Then she gave the mother 100. I think the rent was 6. Anyway. So, the mother now in difficulties because she sells a tray. And she said, well, she had to be sending money overseas to help the same daughter, and now she come back. The daughter saying, well, I ain't a pay none. She ain't going to help the mother. So, of course, the mother going to be in her ways, eh? Then she said, well, she can move out and she's not going to carry the mother with her. The same mother who helped her to college. Then they roof one fixing and get somebody to go over there. The toilet one changing, I bought a new one, up to now it's still over there. The face basin, I am getting plumbers and whatever she needs, eh? She said, well, man, pay nothing. She said, well, she learned from somebody that if they don't pay a certain number of years, they could claim the house. You see the daughter, eh? Then she said, well, I can't give her no eviction. Come here, own the house. I told the owner sent must about 3 or more letters, no response. The mother said, well, she can try and pay, but that's the same pain. Then I hired a lawyer, went to a lawyer's office, and I said, she sent me, send him a letter, right? Well, the doctor said, you can't evict me because you ain't own the house. Owner of the house, write the letter. Go to the lawyer. He said he wrote her. He wrote the tenant. No response. I said he was going to negotiate, right? A payment with her. The daughter said she ain't doing nothing, she ain't helping nothing. And she trying to live out the time in the house. Now the owner came from St. Croix to visit the lawyer. Had to pay him money to write the eviction. Money to write a letter. Money to take the matter to court. He never did. Then he said, well, her brother, come and say the house and she won. And the mother dead and then now she's the one. It was an old house and all of them went to the Virgin Islands and trying to improve the situation. She put a lot of the house in wall. Now, this is what? Some 17, 8 years now. No movement. 8 years, And this is a person that I was showing compassion on. But some children just ungrateful. Now, how do you deal with another? By the way, I took a tenant one time to the court. She owed me 7 months rent. She used to punish me. Don't call her. You disturb her. What I wanted to do. You know those kind of remarks that I make? So I took her to court and the magistrate ordered her to pay. But she owed. To my surprise, he asked her how much you're working for. She was working for $2,700 a month. The rent was $600. came on. Then I took her back. Then the magistrate ordered her to pay. The fees, coming to the lawyer fees too. I think it's a kind of fee. And tell her, well, go and pay the balance. She come calling me, Mrs. Henry, and she this and that. She working the same 2,700. I took her back, and the magistrate ordered her to be evicted, to leave the property.
Carla? Not to offend you, but we're kind of on strict time, so can you kind of condense the question?
Yeah. She still didn't want to pay. Some kind of sorry story.
Mm-hmm.
Sometimes, but the lawyer now will charge me to take the matter to court. When the judge passes judgment, the magistrate, still I'm making fees payment to them, so they end up getting twice. You think that's right? If you know the magistrate gonna give you your fees, why take it for the person you carry the matter to? So the tenant already said they can't pay. They end up having to pay to settle legal fees. And what about those who are sublet? You rent them the objection here, somebody else living it, and they didn't tell you. How do you deal with it? Those are my questions.
We thank the caller very much for her contribution. Quite a bit was condensed into that scenario. We're not giving legal advice on specific situations. What I will do is just kind of give a broad perspective on some of the issues that you raised. The first thing is when it comes to agency, meaning that the landlord may be overseas or may not be in the federation, or sometimes they're here, but for whatever reason, they are incapacitated. A landlord can get someone to collect rent on their behalf. The best way to go about this agency is to have the landlord do a power of attorney, giving you the right to collect rents, to sue if rents become, in arrears. Because if you're taking the matter to court to collect arrears of rent, you have to be able to prove your agency, and the surest way to do that is via a power of attorney. In terms of the issues that you related, you have, in your scenario, you raised a mother-daughter situation, but what that is really begging the question is, who is the tenant? At the end of the day, the tenant is not the children. The tenant is the person who you enter into the legal relationship with, and not necessarily their children or whoever else they invite on the premises. And so when it comes to issues like collecting arrears of rent, it's not a situation where you can say, well, 5 persons living here, I'm going to be collecting $100 from each one. Whoever it is you enter the legal relationship with, that is who is going to be responsible for the payment of rent, whether or not other adults are there and contributing. You mentioned the issue of a sublease. That is something that your lease agreement, a properly drafted lease agreement, would cover. Firstly, whether or not the tenant is entitled to sublet the premises, and if yes, whether or not the landlord requires a say or not in that activity. You can have situations where tenants are making more off of the premises than the landlords, but at the end of the day, once that tenant is in possession, there is a lease and there is no restriction to subletting, they can sublet and charge for the premises. You also raised an issue of adverse possession when you said the tenant is of the view that if they remain on the premises long enough, somehow by magic it will become theirs. The law does not work like that. Once you enter premises pursuant to a lease, adverse possession would not come up, because adverse possession covers situations where people enter premises, they don't ask any question, they're not there based on any permission, they are treating the premises as their own. But if you enter premises based on a lease agreement or even a license, then that would negative any inference of adverse possession. And then the last point, fees versus costs, I think that's a point that you raised. Now that is a matter that is specific to each lawyer-client relationship. However, persons must recognize that if you go to a lawyer's chambers for legal work to be done, the person who is engaging the lawyer is the one responsible for the fees. So if a lawyer tells you that there is a cost to do a notice to quit, that is your responsibility, not the tenant's responsibility. If you go to court, for example, and you're successful in evicting your tenant, or you get a judgment for arrears of rent, and the court awards legal costs, the first point is that costs are not always awarded. And so if costs are not awarded, then the lawyer would not get that cost. And secondly, what amount of that cost, if any, the lawyer retains is based on the retainer agreement between the client and their lawyer. In some cases, the client gets back the legal costs, it is offset against fees. In some cases, the lawyer takes both the fees and the costs. That is a matter for you and your lawyer to work out between yourself by virtue of whatever arrangement that there is. And all of these kinds of questions basically is bringing me to the final thing I wanted to touch on, which is the reason why a lease agreement is important. A properly drafted lease agreement is extremely important, because if the lease is drafted properly, then it would cover a lot of these questions that arise after the fact. And so, okay, all right. We have a caller on the line.
Good morning, caller.
Yes. This is the voice that was there probably first. I'm Winston, welcome again. And I'm posing a question to you, my lady. Does a situation called contingency is practice in sentence? I don't have to go in detail, but law, you try to get a lawyer, you don't have the money to hire the lawyer on the spot. I know in sentence, most lawyers like to have monies up front for them to pursue whatever concern. But does any lawyer practice contingency if the person who brought the case, if they win, that's where they take their payment from, or they just practice an upfront fee? Because one, it could be a hardship on the client could have a case, but they don't have the money to pursue the case. So it's either a case that should be deemed legal and should have representation, but because of finances at the spot at the time, the lawyer denies that case of trial because it's like, you ain't got no money, so I'm not going to waste my time. It's like money up front. Now, which caused me to move to the question, can anyone, in terms of any legality, process their case without lawyers? And that's being self-represented. I would like to know those two questions. Like I said, I have a lot, and it's a very interesting topic, and the panel should come back again, or other lawyers, because we need to know what's going on in our country. I do take contingency cases to lawyers, and they accept contingency. And when, like I said, they take their fees from the settlement, or if you lose, they just let it go. So I'm not going to ask more than those questions.
Thank you very much, caller. Okay, let me see. Lawyers charge fees based on different bases. So you can have a situation where there is a fixed fee for a particular job to be done. The fixed fee is sometimes reference to things like the complexity of the work that the lawyer has to engage in. It also will depend on the experience and seniority of the lawyer. The fee can be based on whether it is an urgent matter, so the lawyer has to drop everything they're doing and devote their time and attention to it. In a fixed fee scenario, you will know what that fee is and you would be expected to pay that fee up front. Lawyers also charge based on an hourly rate. Some matters are charged based on time spent when a lawyer is not able at the outset of the retainer determine how much of his or her time would have to be allocated for the matter. And the third way is the contingency fee, which you described, where you do not take any monies up front. You take a percentage of whatever the judgment amount is if the client is successful. And under our Legal Profession Act, a lawyer cannot charge more than 30% contingency fee. So yes, contingency fees are applicable in the Federation. That's just a matter for you and your individual lawyer. And what was the second question?
That was it.
No, there was a contingency fee and then there was something else. No, this last caller.
That's all I have in my notes.
Okay, so maybe I thought there was something else. No. So what I will do, I see the time is going. So what I will do is to basically just wrap up the discussion by basically encouraging that whether you're a landlord or a tenant, prospective landlord, prospective tenant, that a written lease agreement is entered into, a properly drafted lease agreement. That is the safest and surest way of safeguarding, your rights. And when I speak about entering a lease, I'm not inviting anyone to simply go on Google and Google a lease, or go on ChatGPT and download a lease and use it. A lot of the times, persons simply go online, pull something off and use it. I find that to be very dangerous, because you might be working on one of those internet leases for many years without problem. And so you are comforted by the fact that, listen, I've been using this internet lease and I've never had any issue. But your lease will only be tested once a situation or a problem arises. I cannot count the number of times over the years in my chambers persons have come to me with landlord and tenant situations, and their lease says at the bottom, the governing law is the laws of New York, or the governing law is the laws of Canada, wherever the lease was downloaded from. That is just basically adopted without understanding the implications of it. And I always tell clients that if I have a pipe in my house that is burst, I'm not going to suddenly assume I'm a plumber and just go and start fixing things. There is a reason why lawyers are here. We have a lot of training, we have been exposed, and we are also familiar with the laws. And so your lease agreement must be in conformity with the laws of our federation. And the good or bad of it is that we don't have something called the Landlord and Tenant Act, where every single thing is nicely laid out, so you can just go to this one document and find out all you need. We have a number of different legislation that covers landlord and tenant issues. We have the Rent Restriction Act, Small Tenements Act, Recoveries of Rent Act. You're not going to know this unless you have legal training. And then in addition to the pieces of legislation that I reference, there is something called the common law which would apply in certain circumstances. And well, when I speak of common law, I'm just speaking of laws that are formed by judicial precedent, and not necessarily a piece of legislation that is passed in Parliament. So you're not going to know what you don't know. And so the best way in which you deal with the written lease, you go to a lawyer, you get a consultation, you get assistance with drafting, and then once you have a properly drafted lease, you can just tweak that going forward when it comes to, future tenancies. But the lease agreement is very important, having it in writing, setting out the things that are required based on whatever, your particular needs are. And so I think I will just thank the public for listening, and it was my pleasure just sharing some thoughts on this topic.
Okay, that would be all for Miss Shelley and Liburd Charles. I must say, wow, that was a very good presentation. It almost seemed as if I was in a crash course at Norman Manley, and I'm ready to do the exam right now. So I would just like to say a heartfelt thank you to Miss Liburd Charles, and I'll now invite Mr. Adlai Smith to take over the discussion.
Yes, good morning, St. Kitts and Nevis. It's good to be here. It's a privilege to be here. I am your Director of Public Prosecutions, Adlai Smith, and I am here to talk to you about the significance behind the guilty plea. All right, well, a lot of times police may charge you with a particular offense, and you may think you've done something wrong. Now, the fact that you think that you've done something wrong doesn't necessarily mean that you're guilty. But similarly, or conversely, the fact that you plead not guilty, or in other words, tell the court that you're not guilty, doesn't necessarily mean you're innocent. So, when we're talking about guilty pleas, what do we mean? A guilty plea basically is a formal admission to the court during a process called arraignment. And arraignment simply means the court asks you, sir, with the charge having been read to you, how do you plead? Are you guilty or not guilty? And you say one of the two. But when we talk about a person being guilty, it's basically a person saying, I formally admit to the essential elements of the offense. So what do I mean by the essential elements of the offense? Well, let's say for argument's sake, let's take, for example, the crime of larceny. Larceny is defined as where a person takes and carries property belonging to another without a claim of right made in good faith with the intention to permanently deprive the other thereof. That's a lot of elements. Now, you may have taken something dishonestly without a claim of right in good faith, and you really take it up for sure, right? But you may not have had the intention to permanently deprive. And you see, the thing is, for you to plead guilty and for the court to accept that, they have to be satisfied that all of the essential elements of the offense have been satisfied. Now, what is an example of a non-essential element? All right, let's say, for example, you had a break-in. Now, let's say it's breaking of KFC. No, let's use churches. I just had churches the other day. Let's say somebody broke into churches. Right? God forbid, of course. Right? Chicken not too bad. Right? Let's somebody break into churches. You get a charge, you broke into churches. Let's say on the 12th of, argument's sake, 12th of December, 2024. All right? That's the charge that's put to you. But you know that you broke in on the 11th, right? Now, the fact that you broke in on the 12th doesn't make that much of a difference. It's not an essential element of the offense. If you've actually broken into the place, the Crown or the prosecution can simply tell the court or the jury that the date is not an essential element of the offense. The fact is, the main elements, the fact that the person broke in and they might have taken something, as the case may be, right, that is enough to satisfy the elements of the offense. So, in sum, when a person is pleading guilty to an offense, they are saying, I admit the essential elements of the offense, put simply. Now, a lot of times, and I hear this all the time, people say, but the court giving too much discount. You're getting discount higher than what you get on a sale at Black Friday, which it says is coming up in a couple of weeks, right? Why does the court give 33 1/3%, which is 1/3, and so on and so forth? Well, I want to explain it to you. You see, ladies and gentlemen of the Federation, the court realizes that there is great value to pleading guilty in the system. And let me explain. All right, there are about 3 terms in a court year, and a court term may last somewhere between 10 and 12 weeks, depending on what time of the year it is. Now, for argument's sake, at the present moment, there are probably about 60 cases in the High Court. Let's use the High Court for reference. 60 cases for trial at the High Court. And there are always cases being added on ever so often, every week, every couple of weeks, as the case may be. So that case number keeps going up. All right. So, how long does a typical case last? Well, that depends on a number of issues. Like, for example, how many people involved in the case, how many witnesses involved in the case, how complex it is, and so on and so forth. But assuming you have short trials, a short trial that can last maybe 1 week or so, and generally a case doesn't last a week, it may last a week and maybe a day or so after. But let's say for argument's sake, if we have about 10 weeks, we probably can only do about 6 to 8 cases in a term. You follow me so far? 6 to 8 cases. And that's assuming that they run smoothly. And seldom do they run smoothly in St. Kitts and Nevis. So, mind you, we have over 60 matters on the court term for this term, and we can only do 6 to 8 trials. Let's say 60 minus 8 is what? 52. So that's 52 left after this term is left. But we're adding on every time because remember, criminals don't go on vacation leave. They don't go on sick leave. They still continue to commit offenses. So people will still continue to be charged. Mm-hmm. So you have more and more matters adding on to the list. What do you think going to happen if everybody decide that they have to go to trial? It means that the court will not be able to fulfill its mandate to deal with the matters within a reasonable time. And might I remind you that the Constitution says that a person who is charged with a criminal offense has a right to a fair trial within a reasonable time. Now, of course, what is reasonable time depends on the facts and circumstances of each particular case. All right. So we have a great dilemma if the court cannot try every single case. And coupled with that, we have a problem whereby the defense bar is very small. There are about 5 or so major criminal attorneys, and thankfully I see 1 or 2 upcoming defense counsel, which I have my eye on, and I say there's someone to worry about. And if Mr. Kamal Grant is listening, yes, I see you're a man of great talent coming up. Keep it up and keep your nose clean. But the problem is if persons do not plead guilty, we're going to have a situation where matters take years and years to come to trial. Now, is that an issue here in St. Kitts and Nevis? Ever so often, when I walk the streets of St. Kitts and Nevis, I'm confronted by someone who says, Mr. DPP, why it takes so long for a matter to come to trial. And that's because the Federation generally tends not to know the different dynamics which are causing the congestion inside of the courts. And so this is why a lot of the matters which are dealt with in the court tend to be settled via guilty pleas. The court realizes there is value to the guilty plea. Now, if, for example, I think over 10, 12 matters last term came off the list by way of guilty plea, that's about 8 weeks probably we saved. So you have to understand, given the problem that the court finds itself in, unable to fulfill its mandate to deal with every single case, you already see the value of a person pleading guilty because it saves the courts time.
May I
Sorry?
may I ask a question?
Of course.
Because I'm kind of vague. Are you addressing the question of a person guilty or not guilty, or the time period that a case should go before an individual or are they combined?
No, what I'm dealing with is the context of why we have guilty pleas and why the court ascribes so much of a discount to the point of 1/3 for an early guilty plea.
When you say
So I'm
discount,
putting that in context.
what does discount mean in this context? Because I'm not as versed as you. So
That's fine. We're here to educate
Yes.
the public, right? Let's say, for example, you are charged with, well, God forbid, let's use rape, right? And when the court does its calculations in accordance with the Eastern Caribbean Supreme Court guidelines, the court comes up with a penalty of 15 years, 15 years imprisonment. Now, if you have pleaded guilty at the earliest possible stage, you will get a 1/3 discount, right? So if you pleaded guilty, instead of the 15 years you would have gotten if you went to trial, you now have 10 years to serve in prison. And I don't know about you, but 5 times 365, 5 times 3 is 15, that's 1,500 days.
yeah, but here's a problem I'm seeing now, because I know that individuals, innocent individuals who are unaware of the legal system, can be coerced by a particular lawyer and say, well, you know, if you plead guilty, you're going to get less. And next thing, that individual in their naivety pleads guilty. And I've heard of cases where after the individual pleads guilty, then the system brings down the full brunt of the force and does not apply the, as you say, the word that you use that I wasn't too clear on, right? Discount, yeah. So what is to do with that matter now?
There are a number of dynamics at play, right? You said the full brunt,
Yes.
right? You notice I've chosen my words carefully when I said if you plead at the earliest stage. The earliest stage is before arraignment. I've already explained arraignment is when the court asks you whether you plead guilty or not guilty.
Yeah.
If you plead after that, according to our sentencing guidelines reissue in January of this year, the discount goes lower and lower. So if you are pleading, for example, at trial, the discount goes all the way down to 10%.
But that is my problem. My problem is, from my perspective, I am seeing that you're putting pressure on an individual to plead guilty as quickly as possible when the person might not be guilty, but the person not understanding how the court works. This is what I'm seeing from my perspective, not understanding how the court works. Says, okay, let me give an instance, because you said there's another thing.
Well, sorry, before you continue, it is wrong for a lawyer to pressure a client into plead guilty, to use your words, to pressure a client into guilty.
But just the fact that you have a time span, which as long as that person pleads earlier, the court is more lenient, as opposed to if the person prolongs the case, that is pressure in itself. And as long as I'm aware of it, it is pressure on me.
No, well, first and foremost, because I developed a structured approach to this particular presentation, I wanted to say all I said with respect to the reasons for the maximum discount of 1/3 to give context to the situation. So what you're really asking is, what really is the best time or the ideal time to plead guilty? And the best time, which is the earliest time, is determined after your lawyer has received something called disclosure.
But that isn't the correct. You're saying something that I didn't say, because I didn't say about best time. I'm saying there shouldn't be a pressure of me pleading this point to get leniency as opposed to no. That is a pressure in itself.
The point I'm making, the real pressure, if as you call it, will come after you've received the disclosure, which is why I made reference to the disclosure. Let me just say quickly what disclosure is, because the members of the public may not be familiar with that particular term. Disclosure is basically what the prosecution, myself and my fellow prosecutors, will rely on to show the court or the jury, as the case may be, why you are guilty.
Okay.
So you get the statements of the witnesses, you may get documentary evidence that the prosecution intends to rely on, and you may get photographs, as the case may be, reports, as the case may be. And all of these things are what the lawyer now has to take into account in determining what is the level of the case against you. How strong is it, right? Depending on how strong it is, if it is strong in law as opposed to strong in the court of public opinion, because there's a difference. Because you see, the thing is, while somebody may think that they're not guilty, because the law is, and the principles apply to the particular facts, you are in law. But you see, it requires some explaining.
But how are you when it is said that you're innocent until you're proven guilty?
Proven guilty in law, not in public opinion.
I'm not speaking about public. I'm saying in a case.
Okay, maybe I shouldn't say public opinion. I really mean in layman's terms then. Because the layman may look at the case and say, hey, I don't think I'm guilty, and so on and so forth. Let's take, for example, and I mean, I figured this question would come up. When people are jointly charged with, for example, let me use an example of a drive-by shooting case I did in Antigua. 4 people, right? Only one person did the shooting. And as a matter of fact, there was a young man in the car. You know, all he did to be convicted of attempted murder is to point out to the other fellas, look the man there. Just by that, look the man there, right? And you see, the thing is, he didn't pull any trigger. He didn't hurt anybody. But the principle of joint unlawful enterprise, the prosecution now is able to establish, hey, he's guilty because he's participating in the offense. By encouragement.
I understand that. Yeah.
Right? No, but I'm saying, right, an ordinary person looking at those circumstances would not think he's guilty, right? Because he didn't pull any trigger. He didn't do anything. All he do is point out to the man. But the says when 2 or more persons decide to go about committing a criminal offense, each of them sharing the liability according to the level of participation, while they have the same intent as the principal offender. Mm-hmm. Do you understand? Yes, go ahead. I think you were going to ask a question.
Not to intervene or interrupt, I should say.
No, interrupt, man. I accustomed to this.
Commercial break.
Oh, sorry.
We're going to be due for news in the next 5 minutes. So,
remember, we have to get in our time.
Okay. Mm-hmm. And how much time by your assessment is there remaining?
A half hour.
A half hour. Yes. Okay, then we'll accommodate that. Mm-hmm. Thanks for that reminder. So, do you want to take a commercial break?
Yes.
WINN is 98.9. 98.9 is Win FM.
This November and December. It's triple the fun at Hosford's Furniture and Appliances and Ashley Furniture Home Store. Shop on hire purchase during our triple cashback season and get triple cashback coupons for free groceries. Plus, a chance to spin the wheel to win every Friday.
Join Sugar Bowl live in store as 3 lucky customers each week spin for fabulous prizes. From flat screen TVs and small appliances to housewares, free groceries, and much, much more.
It's excitement, rewards, and comfort rolled into one. Triple the cashback, triple the prizes, triple the fun. Only at Hosford's Furniture and Appliances and Ashley Furniture Home Store. Hosford's, where style, comfort, and savings live.
Last year.
Could you continue? The system just stuck there, so yeah, you may continue.
Okay, welcome back, listeners, to our panel. We'll continue with Mr. Adlai Smith's presentation.
Yes. So there was a feeling or an express assertion that there appears to be a pressure on a person to plead guilty. Now, when a person comes before the court, and especially now in the age of the Plea Negotiations and Agreements Act, right, there are a lot of safeguards in place to avoid that particular pressure. That's one of the reasons why the legislation is in place. Because, one, where a person has an attorney, the prosecution can negotiate with the person in the absence of the attorney. But they can if the person decides to waive his right. But even when he waives his right, he has to be told, and he has to sign to all this, that he has been told of his right to go to trial, he has been told of his right to remain silent, he has been told of his right to cross-examine individuals, and so on, and he has to sign to these things. When you have these protections in place, these are designed to prevent people from being forced to plead guilty. Does that give you some greater level of comfort, sir?
I think I can say yes, but that is what I wanted, some clarity.
No, that's fine. I have no problem with the questions being asked, right? Also, I was talking about the value of the guilty plea. The guilty plea spares people from coming to court to give evidence. And this is particularly important when we're talking about sexual offense cases. Man, when somebody pleads guilty to a sexual offense, I say, breathe a sigh of relief, because, you're preventing the victim from having to undergo all this traumatic experience in some cases, because not all sexual offenses are traumatic. But for some, it can be particularly traumatic. And if you spare that, the court takes that into account. Now, the thing is, though, again, a big issue for discussion is always, the penalty does seem low at the end of the day after a person is pleaded guilty, notwithstanding it may be a serious offense. And I mean, no matter where I go, whether it be in Antigua, St. Kitts, or wherever, people interfering with the little children, picking them, make them grow. If you understand what I'm saying. But, I mean, there is, again, that value that is attached to pleading guilty, and hence that is why there's that big discount there. Matter of fact, in Jamaica, they've made amendments certain periods of the year, and at the discretion of the Director of Public Prosecution, they can bring matters to the court, and a person can get up to 50% discount. But I think there needs to be some consultation here. in St. Kitts before I asked the Attorney General to pass a similar amendment. But the more we can encourage people to plead guilty, is the more we can get cases moving and people can get their justice. Because at the end of the day, it's best you get some justice than none at all. The longer it takes for matter to go to trial, it means that we have issues like, oh boy, that happened so long ago, I can't remember, and so on and so forth. That doesn't hurt the defendant alone, that hurts the prosecution as well, especially when we have situations where there are multiple counts of offending. I remember this count and when it happened, and this count and what happened, what he was wearing, what he did, what he said, and so on. It is not easy. So when a person pleads guilty, understand the great value to the pleading guilty. Now, pleas of guilty, I indicated before, must be informed. I indicated that there must be disclosure. It's served on you. The lawyer is supposed to evaluate it, read it, and give your chances. Now, I found here in St. Kitts, there is a dilemma, a mini dilemma, I don't know how you want to put it. But sometimes I have heard, or at least it's been alleged to me by other lawyers, that you have situation where he advised the client to plead guilty based on the law. But you may have another lawyer there with him, I can get you off, and so on and so forth. And then that person comes to court following that advice, and they get found guilty. Now that is hard on that individual. I would advise individuals, get advice for pleading guilty from seasoned attorneys who are familiar with the system, who are familiar with the law, who are familiar with your chances. But let's say, for example, you are not a person of means. You're not making a lot of money. You're unrepresented, but you want to plead guilty. Now, you don't necessarily have to plead a lie. Just come clean. Explain to the court. Explain to the court. If you're pleading guilty, you have your issue, but you just want to throw yourself at the mercy of the court. And I can do one better. As prosecutors, we have to consider the tripartite interest. And when I say that, I mean 3 sets of interests. The interest of the complainant, the interest of the defendant, and the interest of the public, or the public interest. We are ministers of justice. The defense aren't ministers of justice, but they do have an obligation to be forthright with the court.
When
Right?
you say clarify that, I don't understand.
Sorry.
I thought everyone who was a lawyer was a minister of justice. That's my naivety we are speaking.
Okay. Okay. So I use that term as it was used in a case called the Queen against Boucher in Canada. The prosecutor is a minister of justice. In other words, the prosecution doesn't seek a conviction at all costs. In other words, he don't strive to win at all costs, because let's face it, modern day reality of court is considered as a win-lose situation. But the notion of the process that the prosecution, or the duty of the prosecutor, it transcends, or it goes beyond winning or losing. His role is to achieve fairness in any given case. His role is simply to present the evidence before the court and let the trier of fact determine, come one way or the other, guilty or not guilty at the end of the day. We're not taking no sides or nothing. Defense counsel, their duty, they're ministers of justice in a different sense.
Okay, that's
They look at justice in a narrow context. But for the prosecutor, it's a wider context. But the point I'm really making is the defense counsel are not ministers of justice in the same way that prosecutors are.
They're officers of the court.
They're officers of the court, right? But they don't have that same thing. But what I was really getting at is that I've done cases when I was a prosecutor in Antigua where the person is unrepresented. As a minister of justice, I can mitigate on behalf of that person. Because like I said, the tripartite interest, the interest of the public, the interest of the defendant, the interest of the complainant. So I can mitigate just as, but of course, the accused is going to have to consent to that. But the point is, I mean, I know legal fees here in Antigua not the cheapest. Sorry, here me Antigua, a lot of mercy. In St. Kitts, and not the cheapest, right?
In Antigua, they are.
I haven't been there in a while. I mean, the fees tend not to remain stable.
Okay.
That's all. They go up with the cost of living, right? There was a point I wanted to make as well too. You know, sometimes in a joint trial, like for example, you have maybe two accused. The trial already started before the jury, and so on and so forth. And guess what? Let's say you want trial. Or one day you see your man get up and say, "Well, my plea, I'm now guilty." What do you do? Everybody may start to wonder, is he guilty too? Why he not pleading guilty? The other man pleaded guilty. Now, there are one or two things that can happen in that scenario. The court can give a direction that the fact that your co-accused, the person who was charged with you, the fact that he has pleaded guilty doesn't mean that you're guilty. You are to evaluate the evidence on what you have heard, but you're not to include that in deciding whether he's guilty or not guilty. Sometimes it may be that given the context, sometimes it comes out that one accused may have said something about the involvement of you, and so on and so forth. In which case, a smart defense lawyer would say, you know what, notwithstanding the fact that he has pleaded guilty, I think the fairness or the justice of the case demands that there be a retrial or separation before another jury in fairness to the individual. That is one thing I thought of when I was thinking about what I was going to say. Now, I spoke earlier of the Plea Negotiations and Agreements Act. I spoke to you already about the protections of that, and I realized that, you know, persons may not necessarily be familiar with what the act is all about and so on and so forth. But I want to put it in plain and simple language, basically. Now, in addition to the protections, the advantage you have is that if you have multiple counts, you can say, hey, Mr. Prosecutor, I see 5 counts on the indictment or on the charge. Can I plead 2? And you drop the other 3. This is what plea negotiation is about. Now, the thing is, when a prosecutor is determining whether to accept that particular plea, he has to consider, okay, if we had gone to trial on the 5, what is the likely result? Now, if the offenses are all the same charge, committed by the same defendant against the same complainant, the court is going to order what is called concurrent sentences. In other words, if he sentenced the person 5 years on each count, 5, 5, 5, 5, 5, 5, 5, the layman might say 5 times 5 equals 25. But it would be 25, it was consecutive. But when it's concurrent, all the sentences start at the same time. So at the end of the day, you don't serve more than 5 years. So you can see if the prosecution say, all right, we will accept those 2 counts. Using that specific example that I use, we'll accept those 2 counts. You can't prosecution because at the end of the day, if you went to the 5, you're still going to get the same number anyway. So in these circumstances, the prosecutor has to think strategically and pragmatically, have regard to the need to save the court's time, have regard to the need that other people want their justice. You understand what I'm saying?
I'm glad you clarified that point.
Yes.
Because I used to always wonder, why is it that some sentences were served concurrently as opposed to, but now you're saying as long as they're similar.
Yes.
And okay, I understand that.
Right. If, for example, they were with respect to a different defendant, let's say you had 2 and 3, right? In that circumstance, I would say, okay, if we're taking a plea, I want 1 for each defendant, because I know at the sentencing hearing I'm going to be asking for consecutive sentences because it's 2 different complainants. You see where I'm going?
Yeah, I understood. That's
All right.
why
Very good.
That's why I was glad for the clarity there.
No, and I'm glad to give the information to the public, sir. All right. With plea agreements, right? Also, we can agree as to let me use an example rather than give the general principle. Let's say, for example, there's a murder charge, but from the case there's also a basis for a manslaughter plea. We may decide to take a manslaughter plea once there's a basis for it, because the higher courts have indicated that if there's no basis for manslaughter, it can be overturned on appeal, right? Or you may have a situation where somebody is charged with wounding with intent to do grievous bodily harm, which means wounding with intent to do really serious harm. A person may decide to, hey, I want to plead guilty to unlawful wounding. And it may be in a situation, I think unlawful wounding here carries a maximum of, I think it's 7 years, and wounding with intent to do really serious harm carries a maximum of 20 years. Sometimes you have a complainant who, boy, they were injured and they want some compensation for their injuries, and so on and so forth. Now, in a situation like that, if we want to minimize the risk of the person sent to prison so that the complainant can get some money as compensation and argue that as part of the sentencing, then we will take a lower count, if you follow what I'm saying, and the person get their justice, so to speak, right? Because at the end of the day, the whole thing is about justice. And of course, with respect to the Plea Negotiations Act, the Director of Public Prosecutions is to take into account, he's supposed to consult and take into account the views of victims. In other words, it's not some secret backdoor deal we have with the Defense Counsel and so on. No, we have to consult with you, hear your views and so on. And the court has to inquire about, have you consulted with the victims? What are their views? What is the victim impact statement? And so on. Where is it to show the impact of the offense on them? And so on and so forth. Now, a court may reject a plea agreement if it is not in the interests of justice. That is an important thing to note. So, here is the thing about pleading guilty, and it's always important to know these things. Pleading guilty happens not just in a court context, but in the context of a person's life. Right? In other words, realize that with pleading guilty, you may be injuring, for example, your chances to get a visa, or you may lose your visa, or you may lose, depending on your employment contract, if you commit a criminal offense while on the job or while in the course of your employment, you may lose your employment. So those are things which you must be told by your attorney, because your attorney is on their duty to inform you about the discount and so on and so forth. But they may not always tell you these other little things that you must bear in mind. And to add into your point, a law cannot force somebody to plead guilty. If that happens, Violet Williams, you know the address for the Bar Association, the Disciplinary Council? You can make a complaint. What's the website now? Tell them the website. Info at. Don't worry, we're getting that, because we understand sometimes these things happen.
Yeah.
Right? When these things happen, I believe in for it. If the Bar Association won't hold you accountable, trust me, I will. So, while that information is being laid, it is wrong to force or pressure somebody to plead guilty. If a person wants to go to trial, then they go to trial. The counsel has to accept those particular instructions, because the lawyer is a creature of instructions. Where you have to report an attorney, if, for example, he breaches that solemn obligation to you to take instructions, you can make a complaint about professional misconduct, and the information can be found at this particular website, info at sknbar.org. I repeat that. That's info, I-N-F-O, at sknbar.org. You sure that's not the email address on the website? I think that's the email. Sorry, the email address. Right. And once you do that, one of the friendly committee members will reply to you and guide you to the process. I believe it's on a website. You can download the forms and make your complaint and so on and so forth. I don't expect to be hearing that lawyers are forcing persons to plead guilty. It is a ground of appeal. Oh, sorry. The website, for those who are interested, is www.sknbar.org, and you will find the information that you need there. Right? So, does a guilty plea limit the right to appeal? Well, if the guilty plea is found by the appellate court to be voluntary and unequivocal, in other words, it is clear. What do I mean by unequivocal and clear? You know, you ever come to court or go court and you hear somebody say, you're not guilty with an explanation, right? That is an equivocal plea or an unclear plea, right? When a magistrate or judicial officer hears that, they're supposed to be inquiring as to, well, what is this explanation you have? And if after hearing that explanation, they're satisfied that that explanation amounts to a defense in law, then they have to decline to accept the guilty plea, and you're going to trial. You follow? All right. Okay, so I've been made to understand that we are opening up to callers. And I just remind the callers, don't all rush in at once, and bear in mind, keep the questions short and sweet to the point so that as many people as possible can get an opportunity to participate. Let's go.
Just a reminder, callers, you could call 466-0989 or 662-0989 or 762-0989, or you can comment on the Win Media SKN Live YouTube link or the Facebook Live link.
Okay, when a call comes, I'll let you know,
Okay.
so you can continue.
You can continue.
Oh, all right. Well, I didn't have much more to say apart from that. I mean, I'm willing to take any questions, further questions you might have on the issue. But I hope I've been clear with respect to explaining the context of a guilty plea, the significance of a guilty plea, why the court gives that large discount for a guilty plea, the effects of the guilty plea, and the protections that are associated with the Plea Agreements and Negotiations Act, which was passed earlier this year.
Yeah, when you started first, you spoke to, when a caller comes, I'll let you.
No, go right ahead.
You spoke to the onus, or the salient aspect being whether an individual did something. For instance, I'm going to give it to this caller first. Hello, caller.
Yes, good morning, gentlemen.
Good morning. You are.
Yes, thank you.
Oh, it's morning? So it's afternoon. Sorry, sir. Sorry. It's afternoon.
I am
Good afternoon.
Winston Welcome. Let me
Yes.
get my name. Winston Welcome.
Oh, Mr. Welcome.
Now, in respect to ongoing situation in St. Kitts with the SSD.
The what?
In
SSD?
terms, I am on the grounds, just like others, to repeal.
Hello, caller. I'm going to kind of, you wanted to stay in the vein of what you're discussing, right?
Yes.
Okay.
Guilty pleas, because other persons will want to ask questions on
caller, that is out of the purview. Okay, so.
the special.
Okay, so so let me go ahead. I have to answer the door there. Okay. Go ahead, speaking until I've got to answer.
Okay.
Well, I have a question. You were touching on the early guilty plea giving a discount.
Yes.
Is there ever a time where it is too late to give a guilty plea? Up to what point can a defendant plead guilty?
You can plead.
Okay. We have another caller.
We've had situations where people have pleaded guilty when the jury deliberated.
Yeah,
the discount is very low at that stage.
Go ahead, caller.
I, as a citizen of the Federation of St. Kitts and Nevis, have a problem with a certain law. And I, as a citizen, have a grievance, and I file on my behalf to make my argument why it should be overturned. Moving forward, I make a case with my summons and complaint. I, as a citizen, instead of going to a lawyer, I will take that time and do that for myself. Am I allowed to do such?
Okay, I think we need a little bit more context to understand the question.
Well, I was given the scenario of the SSD, but it boils down to, and
he's
caller.
persistent. He's being persistent, but I don't see that as
Relevant.
Callers. We're speaking on the issue of whether an individual is guilty or not guilty, and the process of making that plea and how it works out in the course. We would like you to stay in that vein, please. Go ahead, caller. We have another caller.
Good morning. Well, good afternoon, sorry.
Hello, caller. Not getting anything here. Okay, so we don't have a caller.
All right. Well, I mean, as we're in the...
I was speaking to
Yes.
the fact that when you started, you said, for instance, you said somebody broke into a house, right? And whether the individual broke into the house on one day as opposed to
Yes.
the other day,
Yes.
the salient point is that they broke into the house.
Right.
I remember that.
Right.
Okay. So my question is, using a hypothetical, I broke into a house on Monday this week, right? Someone broke into the house, same house, on Friday, right?
Friday last.
Friday after the Monday.
But
Two
okay.
break-ins.
Yes.
Friday last,
Yes,
yes.
yes. I'm using a hypothetical. Okay. Now, I have a reputation using the hypothetical of being a criminal. Okay. So the cops come and pick me up and say, we suspect you broke into the house, right? But then when the case goes to court, the court is saying the house was broken into on Friday, right? Now, your point as to whether or not the point is you broke into the house. So how then do you prove that? Because you can't just say because I'm a criminal, I broke into a house, and there's a disparity between when I broke into the house and when the other individual broke in. You don't know I broke into the house on Monday. I know I broke into the house on Monday, but I'm not telling you I broke into the house on Monday. So what do you do in a case like that? It's about proving the case, right?
Right. I mean, in a sense, you've answered your own question now. how the case reached court in the first place? There had to have been some evidence against you. Now, sometimes you have situations where, and unfortunately, I'm sorry that it still continues, but the tenuous, some of the evidence is like on a slim thread.
Yeah.
That's sometimes when it reaches us, or sometimes when it reaches me, because I have assistants who perform my functions on my behalf, and so on. I might say, you know what, we're just going to have to withdraw this particular case. I even had a case where a church was broken into and the man was charged on suspicion. What is that? Because he was a person who is a characteristic breaker and so on. The fact that you are a characteristic breaker doesn't necessarily mean you broke on a particular occasion.
Okay.
You have to have the evidence. There must be some evidence tying you to the crime before we can even talk about whether you broke on Monday or Friday.
Okay, so that is what, you understand why I wanted the clarity.
No, I appreciate the clarity.
Yes,
You're entitled to ask questions for clarity as a member of the public. Ask your question. Once your question is reasonable, it will be answered.
Okay, so I have no other questions.
You have no other questions. All right. Well, I mean, it's really been a pleasure being here. I just want to wrap up by underscoring the same point I made earlier. guilty pleas save the criminal justice system. Right? A person might say, well, boy, I don't want to plead guilty because I don't want to lose my visa, and so on and so forth. But if you really are guilty, think about the effect that you are having on other people who use the system. Is this your opportunity to be selfish and hold the system to ransom? Or is it not more reasonable to take accountability for your own actions? I mean, some of us don't like the term accountability around here. Well, that's your business, right? But at the end of the day, I mean, don't be surprised if the court deals with you severely. Well, a court can't deal with you severely simply because you did not plead guilty. All it can do is not give you the discount if you did not plead guilty. But don't blame nobody if you miss out on the discount and you follow some fool lawyer who tell you that you have great chances and so on and so forth. You remember sometimes the longer a case goes out, the lawyer may have an interest in bleeding more fees out of you. I'm not saying that that is the position I have here, but you have to think strategically and so on. Think about what is in your best interest and use the 15-year example. 10 years is better than 15 years by any stretch of the imagination. Right? So, again, it's a plea to those out there. Look, if you are guilty, oh gosh, come, throw yourself at the mercy of the court. Right? If you find a way of getting that message to me, I will try and see if I can get even a further discount for you, because you are saving the court's time. Because right now, the dilemma facing not just St. Kitts and Nevis, but around all the courts in the Eastern Sea, the OECS, the Organization of Eastern Caribbean Supreme Court, is that there is backlog upon backlog upon backlog. The beauty about St. Kitts and Nevis is that our backlog is not as bad as the others. But we do not use that as an excuse not to improve our system, because at some point, those other OECS countries would have been in the position that we were in. But because they were not aggressive in taking the measures that we want to take, they allowed the thing to go into control. And so not only the horse gone, but the thing that the hay is in the stable, gone out of the stable, right? We want to see what we can save with respect to the justice system. And maybe this might be a good way to segue into the fact that come next year, early January, we are going to have criminal procedure rules in place which are going to change how criminal justice happens over here. At least they're intended so to do. Now, in their current format, they may not work initially, but it's going to put a lot more pressure on prosecutors and defense lawyers to get the act in order. And those who did not have to pay costs before for wasting the court's time may find themselves having to dip into their pockets if they waste the court's time, right? But the point I'm saying, we can't all achieve this unless we have some collective responsibility, having regard to our respective functions in the system. And I guess this is a nice way to end, like I always end when I speak to the members of the Federation of St. Kitts and Nevis. Remember our national motto, country above self. Thank you.
I would like to make this final statement. The reason I asked about discount is because I didn't understand, but even though I now understand, I still don't kind of like the phrase discount, because it gives me the impression of when you go into a business space and you say, I'm going to give you a discount on that TV.
Exactly
Black Friday.
So I understand what it means, but I would prefer you say, I'm going to be lenient, I'm going to give you some time off, or, the discount sound. But that's your purview.
I don't know if it's a marketing term, right? I mean, who don't like a discount? Right. The only thing you don't want discount is your pay.
Yes, but discount is the language that the court uses.
Oh, that's the language the court
uses. That's actually the language the court uses. A 1/3 discount.
Okay.
But at the earlier stage, after having received disclosure.
Mm-hmm.
Yes, I just wanted to chime in with one point as we're wrapping up on this issue.
Go a little closer to the mic.
I just wanted to make one contribution to this issue that was thoroughly canvassed by our learned director.
Thank you.
A guilty plea can also be, in my mind, very important in cases where the penalty may not be a lot of years, but a defendant may find themselves waiting on remand for quite a bit of time for a trial. And you want to avoid a situation where the maximum you could get for something is 3 or 4 years. You are waiting for your trial, maybe you did not get bail for whatever reason, and you end up spending 2 years on remand. And by the time everything is concluded and the sentencing rolls around, you may not have even gotten 2 years. So what I think it does as well in cases where the penalty may not be for a large amount of years, that could be an added incentive for a defendant to plead guilty once they know they are, they have committed the crime, because outside of bail, you will have to be basically waiting in the prison in order for you until your matter comes up for trial. So I could see a usefulness in a case like that.
I always believe nobody should plead guilty if they're not, in fact, guilty. But of course, it's always guilty in accordance with law. And I want to make one last point to support what my learned friend just indicated. If you are unsure about where the court may be going with respect to its penalty, nowadays we have something called Goodyear indication or maximum sentencing indication at some time or sentencing indication. And what that simply is, the court is asked, if the person was to plead guilty today, what is the likely penalty I may get? And then the court asks the prosecutor, can you present the facts for this particular case, please? And then there is some mitigation. And then the court writes all of this down, steps down for maybe a couple of minutes, comes back and says, if the person pleads guilty today, this is the likely sentence for today. But this applies for today only. You know, you have some stores which say the discount is for today only. Apparently that is also in the court as well, right? Because you risk the penalty going further. And you see, this gives you an idea that if this is the penalty today, Lord, if I'm really guilty and wait until the end of the trial, it's going on, right? So remember, if you are in doubt as to whether, if you're unrepresented, ask the court. My lord, or your honor, as the case may be if you're in the magistrate's court, can I get a sentencing indication, please, on this particular offense? And they will give you the sentencing indication. And that could be, a way of helping you determine whether you should plead guilty or not.
Yes, that's a very good point.
I'm sorry I didn't mention that before, but it's because that very good point made by my learned friend, Mrs. Liburd Charles.
Do you want to entertain a final caller? Or is it?
Yes, of course.
Go ahead, caller.
Hi, good morning. Good morning to the panel there. I was listening. I don't have to plead guilty for anything. Thank God for that. But one of the things I would like to ask, I would like y'all to have another panel sometime maybe in the new year as it relates to the conduct of lawyers who you ask to provide a service for you, and then they never deliver, but they keep your money. So that might be a good topic for the new year. So I hope you could consider that.
Yes. Well, your Violet, you'll put that to the association, and they will decide whether an appropriately constituted panel could deal with that issue.
Yes, I will.
Yeah. But I mean, we appreciate the fact that members of the public are interested in this organization. It shows that the Bar Association takes the idea of education of the public very seriously. I mean, we have taken time out of court and things that we would otherwise do. Don't ever think that the DPP don't have nothing to do. The DPP always have something to do. Even our dreaming are working, right? It's a very intense exercise, and the same thing for Miss Liburd Charles. It is a sacrifice to come here, but we regard educating the public as something which is very important, because we know that out there's a lot of misinformation about the justice system, whether it be on the civil side or the criminal side. activities like this help to counter that misinformation so you can be armed with the information that you so desperately need and deserve as a citizen of the Federation of St. Christopher and Nevis.
Okay, to close, ladies and gentlemen, that brings an end to our discussion for the St. Kitts and Nevis Bar Association Law Week 2025. I would like to invite you to stay tuned this week. From Tuesday to Saturday, there would be some tips on did you know tips for the week. With that said, I would like to personally give a heartfelt thank you to Mrs. Sherry Ann Liburd Charles and Mr. Adlai Smith for sharing their time, expertise, and insights. To our listeners, I would also like to say thank you for joining us and for your continued interest in understanding the law and the justice system that serves our federation. We hope today the program has been enlightening and has provided valuable guidance. On behalf of the St. Kitts and Nevis Bar Association, I am Josiah Imo, wishing you a safe and productive day. Stay informed, stay empowered, and enjoy the rest of Law Week 2025. Thank you.
Better music, better talk, better radio.
I'm listening, honey. I am listening.
98.9.